And I have no doubt people will probably continue to join us and filter in on the online side and possibly even in person as well. But we will go ahead and start getting started. I wanted to introduce myself and welcome everybody. I'm Christy Horsley with CASA of Central Virginia. We are very excited to be able to do this QRTP training because, again, for all of us participating and even those presenting, it's still a pretty new and novel hearing for us. So we're all kind of learning together and as we go. And also we're excited to have both an in-person component for folks who came to be in the room, but also we're really excited to be able to open this virtually and also allow in people from all over the state, because again, we're all kind of learning about this new hearing and checkpoint together. So excited that we can all be together. So again, on the virtual side, please put your questions in the chat. For people in the room, feel free to pop your hand up if you have a question in a moment, and the owl here will kind of locate the voice and show who's speaking. So, okay, any questions anyone has before we jump in and get started? Okay, so I'll go ahead and introduce Catherine, or Katie Jordan. She actually used to be a CASA volunteer. She went through the training class when she was in her 3rd year of law school in this very room, as it were. And then you did the GAL training once you became an attorney, and now she is a DSS attorney. So she really has been able to see casework from a multitude of vantage points. So she is going to walk through a PowerPoint with us. Also, I will send you this PowerPoint, the slides. I'll send it to you in the follow-up email when I send the certificate. And then also Shayna Richardson, I blanked on your last name all of a sudden. Shayna Richardson is the Foster Care Supervisor for Lynchburg DSS. Foster Care is the one that is going to be writing the foster care plans that have to be submitted at QRTP hearings. So again, we look forward to hearing what they both have for us. Thank you guys again for being with us this evening.
Yeah, thank you. And I'm sure Shayna will be able to answer a lot of the questions that I might not be able to answer. But there's also a chance that we may not know the answer, given that this is all so new. So we are thankful that you all are participating today, and we can go ahead and get started. So the first thing that I wanted to discuss a little bit is that this is all in response to the Family First Act by Virginia. That was in response to federal legislation. And the Family First Act seeks to reduce the inappropriate use of non-family-based placements. And when a non-family-based placement is needed, ensure that children are placed in the least restrictive, highest quality setting appropriate to their individual needs. So what exactly does all that mean? There we go. When a child needs a higher level of support, a non-family-like setting may be needed. For example, this would be a group home or a psychiatric residential facility. For these specific placements, the Family First encourages that these placements be both temporary, focused on the individual's children's needs, and prepare them to return to family and community life. What they're wanting to avoid is children just perpetually being in residential facility after residential facility and never getting back to a place that they can begin to build their family and community. Family First creates a specific non-family based placement type and a structure around placing children in these types of placements. This new placement type is called the Qualified Residential Treatment Program. So why does this matter? First and foremost, it matters because of money. And unfortunately, money is what has to dictate a lot of the decisions that are made surrounding caring for children that have been abused or neglected or in foster care. Specifically, federal funding for foster youth with specific treatment needs is only available if they're placed in a QRTP placement, if it's a non-family-based placement. This slide here shows you just the breakdown of the funding of the federal versus the state and how much in a year's time frame is devoted to each. And so what you see is there's a lot of it is the state money but it is matched by federal funds. And we lose that. And so if you were to lose, half of $210 million, that would be a lot falling back onto the state. And if we aren't complying with the federal, the state could say, we're not gonna supply our money either, which would mean it would fall back into the local money, and that money is very limited. So we're trying to avoid having more money taken out of the local coffers. One thing that was mentioned in my reviewing of all this stuff is that a lot of that local money that would end up getting used is the same money that we would put towards prevention. And so the question of, are we putting a trade-off in the children that we have in foster care versus preventing future families and children from having to enter the system in the first place? So for the main reason why we're here today, what is a QRTP? QRTP is the residential, qualified residential treatment program. It is a non-family-based placement which provides treatment to children using a trauma-informed treatment model. So trauma-informed is one of the requirements of it. There are some other requirements as well. It must be accredited by a nonprofit accrediting agency, and there's a list of which that they have to choose one of. They have to facilitate outreach to the family and fictive kin. They have to have been registered or licensed nursing staff and clinical staff that is there 24/7. And they have to provide aftercare for at least 6 months from placement. And so this graphic here just kind of shows how each of them are a different component that all work together as part of that QRTP model. So when do you need to have a QRTP certification? Here in the blue box, it shows you it has to be a non-family based residential program. So think of any placement outside of an actual home. If you have foster parents looking after a child, that doesn't need to be QRTP or whatever. And it's only for children that are in foster care. You don't need it if it's a parental placement into a residential facility or that sort of a thing. And it also only applies to those that are eligible for the 4E funding. If the child would not be qualified for 4E funding, it may not necessarily matter. Well, I had mentioned previously, there is some state things that are kind of going in line with the federal. That might be something that we have to watch out and change. But as of right now, it only specifically applies for those that are 4E funded. And any type of program that's licensed by DSS, DB, HDS, or DJJ, regardless of whether or not it's a Medicaid provider, can apply to be a QRTP facility if they choose to, but that doesn't mean they necessarily are.
To your knowledge, like certified by DJJ, would that include detention homes or like?
I do not think that it would include detention homes. But I'm not sure.
Question in the chat too.
Oh, yes. Could you explain 4E funding? Because I hear that tossed around at FAT sometimes, but yeah, before this, I didn't really know what that was.
I think that might be a great question for Shayna.
Okay, so 4E funding, like globally, is, as I understand it, because I understand it in a different way from the DSS side, right? So but it is an offshoot of like Social Security type funding. I mean, that's really ultimately where it comes from, and I may not be explaining that great. But what it means in foster care, 4E in and of, so it's called the Title IV Act. I mean, that's where it comes from. It's an offshoot, and I think it's Section E, and so it's called Title 4E. So I wasn't, fully prepared to speak real knowledgeably on that, but again, I do know what it looks like for us. So every child that comes into foster care is assessed for their eligibility for Title 4E funding, every child. And there's a host of things that can impact that. But when a child comes in, a benefits program specialist is going to get an application, and they're going to look at a host of stuff. So it starts from the very first court order. They're looking for court order language in the court order that talks about reasonable efforts to prevent removal. They are looking for also language, what they call contrary to the welfare language. And so those are the top assessments that they're looking for. If for some reason a child doesn't meet those requirements, they're never 4E eligible. That's it, it ends there. So some of the other further assessments are whether or not a child is in an approved placement. It is income-based. It actually does look at the income of the biological parents, because they have to meet a certain threshold. If the biological family is over a certain income level, then they don't qualify due to what they call excessive income in the removal home. You also, children who are determined 4E eligible also have to meet what they call a deprivation category. And now you're going to really test my brain. I know that they are, so you have to prove citizenship. That's one of them. And that's also done like through a birth certificate. So not just legal like citizenship, but also like birth certificate. I can't think of the word I'm trying to use. I apologize. Some of the deprivations are being in a single parent home. So if you've got a mother or a father that's absent from the home, that's considered a deprivation. Having a case in which paternity is not established, that's a deprivation. Gosh, I can't believe, if anybody has further questions, I can find it. I can't believe that I can't remember. I'm trying to visualize the application. But every case is assessed on all those criteria. And if anywhere along the line, anything, disqualifies a child for 4E funding, then they're never eligible. So they're only assessed once. And the benefit of 4E funding is what Catherine already said. So it offsets the cost to the state. It offsets the cost to any locality because the match is lower. And then 4E funding, it's federal funding, so it's a bigger pot of money, and it can be used to pay for maintenance to foster parents or treatment foster parents or kinship foster parents, enhanced maintenance to those entities. It's used to pay for the clothing allotment that a child receives. It's used to pay for daycare. And it can be used for certain types of transportation, eligible transportation. And so it's a cost savings measure, some of which is in our control when kids come into care and a host of which is not, but each child is assessed. I don't know if that helps or brings up more, but
more than I knew about 4E before you started talking about it.
There you go.
And when you say it's eligible for some types of transportation, is that specifically for the child, or could it even be like to help family getting to visits?
The eligible transportation is to transport a child to visit family. So it actually does not work in reverse, oddly enough, but it can be used to transport a child to visit family, and that can look like a mileage reimbursement. If you had an older child and honestly you were putting them in an Uber, you could pay for that. It could look like a bus ticket, a train ticket. And it can pay for school transportation as long as a bid has occurred and it has been, if it has been determined that it is in a child's best interest to go outside of their home school, and then we can make arrangements for the transportation. 4E can pay that transportation. 4E can even pay the school. If the school, if you have a school district that says, I'm willing to do this, but I've got to pay an extra bus driver, 4E can actually cover that as long as the bid has determined that that is the school placement for that child. So those are the only two. Those are the only two.
And the 4E funding is not limited. The numbers that I had posted previously was just an example of a one-year budget for Virginia. It's not limited by some set cap necessarily. It's limited by our ability to match those funds. So the more money that we can save to match future funds, the further our dollars go.
Okay. Thank you. That was very
sure.
So is the designation of a QRTP an additional licensure status with the state? Not really, but it is a additional certification that residential facilities can apply for. They don't have to, but if they would like to receive those federal funding, then it's something that it behooves them to attempt to begin that process. And like I had mentioned previously, this is a new thing that didn't start until it was July of 2021 is when this officially was enacted in Virginia. It did start federally, I believe, in 2018, but it wasn't enacted in Virginia legislature and policies until last July. So some important deadlines that are just good to kind of generally know about is that there's a 30-day window, a 60-day, and then an approximate 12-month review. And so those are things that you just kind of put in the back of your mind, and we'll go through each one individually. So within 30 days of placement in a QRTP, there's two things that have to be done. The first is there must be a clinical assessment of the child, and this must be performed by a qualified individual. As described in the code, it's a licensed mental health professional, and that individual has to then assess the appropriateness of the placement, and that is in line with Virginia's clinical assessment model, and through that they determine if that placement is the best fit. So it might be that the placement that you're seeking for the child isn't the best fit. There might be a different facility that might potentially be a better placement, that might be least restrictive or some other criteria. And then additionally, DSS has to file the paperwork with the court by that 30-day mark. And included in that paperwork, I'll go through it later, but it will include that clinical assessment that also has to be done by that date. So you could have a quick turnaround there with trying to get that stuff figured out. Do we have a question?
Somebody in the chat had asked about, will there be any pushback from RTCs?
Residential treatment centers.
Gotcha.
So within the different categories of residential facilities in Virginia, there are those that are QRTP certified and those that are not. There is no cost for them to apply to be a QRTP facility. They just have to meet the criteria and apply. So really there shouldn't be any pushback from them. And I've noticed looking at the list that most of the facilities that we were using prior to this are now QRTP certified. It may have taken them some time, but most of them are in fact certified at this point.
Yeah, if I could, I will say that there were definitely some residential facilities, even our local one, that some facilities did find it somewhat cost prohibitive for some of the, excuse me, eligibility. So oh my gosh, hold on, give me 1 second. The requirements for their staff, like their staffing requirements, like I keep wanting to say eligibility, and that's not the word I'm looking for, but they're, in order to have the trained staff in place, or for certain smaller group homes or residential type facilities, it might be cost prohibitive to have a nurse on staff. So there were some things, so it's not necessarily a pushback, but there were definitely some that for those reasons, that they expressed that they weren't going to move forward with being a QRTP. Now a psychiatric residential treatment facility, or what they call, I think, a level C residential, they're fully Medicaid funded. So they don't necessarily have to be QRTP because their funding is completely covered by Medicaid. So some folks really just were in a position where they didn't have to. But some of the requirements were cost prohibitive, I think, to some smaller faciliits.
Well, and even the ability
to do that.
To do the clinical assessment could be cost prohibitive, because that means you have to have a qualified individual on staff, because it's their facility that has to do that evaluation. It's not DSS providing that evaluation to them. They're the ones that have to do that within the 30 days. And then yes, the having staffing, 24/7 medical care, that sort of thing.
I think that's what I'm trying to say.
Yeah.
Their qualifications.
Yeah. And can I ask you a question too? I think on the prior slide, you had mentioned that there's some discrepancy between the federal requirements for QRTP and Virginia's, and there, some agencies are trying to sync those. Do you know, is Virginia's more rigorous, or?
So it's not necessarily the QRTP qualifications, because Virginia's QRTP is in line with federal.
Okay.
It's their general licensure for a residential treatment facility. Those are what they're currently working to get in line with what the federal QRTP regulations are. But as of right now, there are a number of residential treatment facilities in the state that do not have that QRTP certification. So those are the two things that they're trying to get more closely aligned, but they're not quite yet. So after the 30 days, within 60 days of placement in the QRTP, the court has to review the placement and either approve or disapprove the placement. They will consider the 30-day assessment evaluation and determine whether the needs of the youth can be met through the placement in a foster home or whether or not the QRTP provides the most effective and appropriate level of care for the youth as specified in the permanency plan for the youth. And those are all things that we're going to go a little bit more in depth in.
And can I ask, we had a question in the chat and it sort of connects with what I was wondering about. So for some of those maybe smaller facilities, let's say a group home that found it cost prohibitive to go through the QRTP process, does that mean that those agencies basically are able to kind of skip out on the court oversight aspect of it? So like if they choose not to become QRTP, then either maybe if we're lucky, Medicaid will pay for it, or maybe FACT will have to pay for it. But do they just kind of get a lower burden then?
I would say that DSS still has the same burden of putting the child in the least restrictive environment. And so that is kind of the check there. This is a additional check for residential facilities. However, because those sorts of facilities that aren't QRTP do often tap into local funding, it's going to encourage DSS to not use those facilities unless they're absolutely required and absolutely appropriate.
Yeah. So I'll add to that, they still, in order for a DSS to utilize a placement, it has to meet the licensing standards that are set by the state. So it's still got to be licensed and approved. What it means to be like a smaller facility like that is if a child is 4E eligible and that facility is charging a daily rate for room and board, which, you know, I can tell you, you know, upwards of sometimes it's $210, $250, $300 a day. That's the kind of like, that's what you're talking about. What that means for that facility or for that agency is that, yes, they can't utilize that 4E funding that's available to that child that would pay that in full. That cost now has to come from CSA, which is sometimes a harder sell for the local agency. It really does depend on your agency and your relationship with your CSA office. And like Catherine said, your CSA is probably going to be a little, so you don't have that court oversight, but you're probably going to have the CSA office breathing down your neck about how soon you can get the child stepped down to a lesser level of care. So you're going to, by not doing that, and we still are going to run into situations where you have to utilize those facilities for a variety of reasons, but you lose your ability to utilize that particular 4E funding. And it does cost the state and the local budget, which, like Catherine said, that state budget can be a capped entity, like it can be. We've, you know, as an agency haven't gotten there, but it's not a never ending, you know, it's not never ending. And then also, you know, your local agency is going to have their own budget, you know, their own piece of that pot. And if your city council, say, has to make a match, it's not guaranteed.
Gotcha.
So,
okay. And the question from the chat, which you may just sort of integrate this as we go on, but Jeff had asked, what is the role of the CASA advocate in ensuring that that assessment does occur, the initial assessment, and for it to be filed with the court?
I just think open communication with the worker and attorneys or whoever is involved in it to ensure that it is on people's mind, I think is the number one. We will talk a little bit more about that in the process as far as the CASA plan and that sort of thing. I did also want to hit on, in Virginia, there are different types of children's residential facilities. And there are some exceptions that don't need that QRTP status. That includes facilities that are for treatment of individuals who are at risk of trafficking or have been trafficked, those that are pregnant or in a like postnatal type care situation. So for example, the Liberty Godparent Home here, that doesn't need to be QRTP because it deals specifically with pregnant individuals. There are different exceptions for certain facilities throughout the state. Additionally, there is 2 different categories of those children's residential facilities, and one of which is called a child caring institution, and that is a group home that does not have the same level of certification as a general children's residential facility. An example of that is locally here is Miller Home, which, because they only receive funding from either family or their own internal funding, not state or federal funding, we as DSS cannot use them as a foster placement. So there are certain facilities that don't have to worry about QRTP because that's just not a part of their goal and mission. And so we're not really utilizing them specifically for the foster care purposes. And so if you go back to the original slide, which I'm not actually going to flip there, but I'll just remind you, the only time where we actually need the QRTP, and it's in a blue box that I have, is if you have a child that is in a non-family based residential program, the child is in foster care, and that they're 4E eligible. If those three things don't apply to the case, then it doesn't matter if it's QRTP as of right now.
So I have a question. So
Yeah.
one of the big things is making sure that the child is or is not 4E qualified. And we can tell whether they're in a foster care or residential, but it seems like making sure if they need a QRT program that they get qualified
Yeah.
for it.
And there's a lot that we don't have any control over with that, like she said, how much money the parents make and things of that sort. But little things such as, did the judge make a finding of reasonable efforts, and is staying in the home contrary to the welfare of the child? Those things can affect 4E funding.
So as a part of the bigger discussion, QRTP applies regardless of the funding source.
Okay.
What happens is, so in other words, if a CSA only child goes into a QRTP and doesn't follow the process, then they have to leave. They lose that eligibility as well. Here, they don't lose their CSA eligibility. They can't stay in that placement. The same rules apply if you don't meet the requirements. It's just that with a 4E child, you're going to lose out on your opportunity to access your 4E funding, and you may or may not be able to use your CSA funding. So you still have to follow the process, the QRTP process. So QRTP is like, I don't know, it has a couple different, there's a couple different things there. But if you put a child in a QRTP, regardless of funding status, you have to follow the process.
And Shana, to sort of connect back, you had mentioned that it's standard at the start, like when a child comes into foster care, you guys do an assessment automatically to figure out if they're 4E or not. And it seems like that would be a pretty simple question to ask the social worker, and they would know. And or if you go to the FAPT meeting for the child, you're probably going to know one way or another, because again, a lot of times it gets discussed. Or
you may not know from FAPT. Okay. That's probably not my experience in Lynchburg. I don't know, because I don't know if the folks that run the FAPT actually know what the status of the child is, honestly. I think they have access to that information, but yes, a supervisor or the direct worker should be able to tell you, and the assessment has to be done, the eligibility has to be determined within 45 days. So, yeah.
I do think the initial question is this child in a residential placement or need a residential placement? Because if they're in a normal foster home, then this is not even a question. It's only for those children that specifically need a higher level of care and cannot be maintained in a family-based setting. Now, if they're in like an acute psychiatric facility, like they're at Christ 6 or something for 7-day stay, like that is such a short time period. We're not going to be dealing with this, even though they would totally qualify because they have all the medical staffing and everything. A child may not necessarily be there long enough to go through the QRTP process. But if a child is going to be there longer than an acute stay, then that is when we would be looking at actually going through this whole process. And after the 60 days of being in placement and the court reviewing it, the court, or not just the court, but the DSS commissioner and the United States Department of Health and Human Services will review the case if a child is under 13 years at 6 months. And if they're 14 or older, after 12 consecutive months or 18 non-consecutive months. So that's where you got to make sure that we're doing things right on our end, because if it gets elevated to the point that somebody from the outside is coming in and looking at it, they can always go back and pull the funding from something that if it hasn't been followed appropriately.
And I'm just curious, from a show of hands from people in the room, or you can put it in the chat, how many people have had a child under the age of 13 in a residential treatment center for 6 months or longer?
As a
Yeah.
special ed teacher.
Yeah.
Yeah.
And we've had kids as young as 5 or younger. Yeah.
Okay, so next is the QRTP and the court process and the purpose and process. And this is where I want to go back and review. Let's see if anybody in the room, or I guess they could send it in chat if they can answer quickly. What is the purpose of the QRTP hearing, and what is the problem that they were attempting to address by making us do this extra work? Does anybody remember?
And we'll give people a second to think so that people in the chat can also type. And maybe for additional context too, while people are thinking or typing, if I'm remembering right, I think the JLARC report that Virginia commissioned on foster care a few years ago, that Virginia was found to be overusing congregate care settings for youth in foster care. And I can't remember what the percentage was, whether it was like 25% of teens or 15% of teens were in congregate care settings that didn't need to be. So interesting point of context that may shape your answer. Okay, yeah, go for it.
I think, if I remember correctly, it would be that you're trying to make sure children are in the least restrictive environment.
That is exactly part of it, yeah. So to safely reduce the inappropriate use of non-family-based placements, and when a non-family-based placement is needed, to ensure that children are placed in the least restrictive, highest quality setting appropriate to their individual needs. So that's the context that we're doing all this in.
Good job, Amy Wilker in the chat. She said avoid long placements in congregate care and at least restricted environment.
Yep. And how frequently are these QRTP hearings held? Initially, we already said within the 60 days of placement. It can be at the disposition of a foster care plan initially, or it could be at the next foster care hearing that naturally would already be scheduled if that is within the 60 days of the child being placed in that residential facility. If it is not, then you would have to schedule a separate hearing for it that's within that 60-day time frame. As far as reviewing the QRTP placement, that will also vary. It will either be at the next foster care placement hearing, or if it needs to be at a separate time frame interval for a child like with APLO, which we'll get into a little bit more later, it might just be at like the 6-month review, which is like the normal. So 6 months would really be the longest time frame you would probably see for any of these children to be in court.
Can I ask, since I have not gotten to the review process yet, what that looks like?
We haven't either.
Oh, okay.
We haven't.
And honestly, I have on here what the requirements are for those review process. But yes, we have only recently even filed the QRTP in 2 different cases. And so it's very much, from my looking at digging into all this, it's very much the same as the initial. It's just a reevaluation of, is it still the best place for the child?
And I think, as I understand it, so far our only experience has been hearings outside of the foster care. Like ours have not fallen in line with kids that have come into care, and so they have not fallen in line. But I guess if you have sort of that initial standalone hearing, then you're going to review it every other time you go into court. So let's say you had one between the 60-day dispositional and the review, because it happened in that time frame and you had to have a standalone hearing. Then you're going to review it again at review, which would be in a couple of months, and then you're going to review it again at 5 months in permanency. But we have not. We had one young lady who went, and she didn't remain in congregate care. She was there for less than 6 months, so it didn't get reviewed through the court or through the reviewer. She was also over 13, but so we have not had one. We haven't had one yet. Get to that point.
So is that feedback coming from the facility themselves, or I guess that's where I'm trying to, I mean.
Is there another formal assessment, like
Right.
another formal assessment,
how
like a
are we
30-day one, or?
deciding?
Yeah,
Because also, isn't there like every month? I mean, I know usually like kids in residential treatment, there's like a monthly summary and treatment plan, and at least some of the language I've seen it there, like they have to document that there's a continuing level of need.
There is a
Should be
requirement.
Data even.
Yes.
And
There-
then they'll look at the data and can make it into charts.
There is a requirement for the facility to do a continual assessment of that child. And so the service worker has to present that evidence at the hearing that the ongoing assessment of the child's strengths and needs continues to support that specific QRTP placement as the most effective and appropriate level of care that's consistent with the child's short-term and long-term goals, and that the child's needs cannot be met in a foster home. They also have to show that the child's specific treatment and service needs and that specific QRTP will address the length of the time the child is expected to need such treatment and services, and that the local DSS efforts to prepare the child to return home and to be placed in a fit and willing relative, legal guardian, adoptive parent, or in a foster home. And there
And-
should be another one there.
And that piece is a requirement, that last bullet point, that is supposed to be demonstrated as well, that DSS is making those efforts.
Yes, those are all things that have to be, and I thought that there was another slide that somehow seems to be missing.
That's all I see on the,
What does that mean? I mean, I guess it's.
Oh,
vision
that is
what
it,
that
yeah.
Look like, but. what
That was
is
one of those
that?
too, okay.
well, I think that's gonna go to the court's perception of reasonable efforts.
Yeah.
I think that's all that's
Okay.
really gonna speak to, but I'm confident that we would have, like, I feel like my expectation would be that my worker has got treatment plans or recommendations. I mean, what we are seeing now more and more and more when we do have to place children in congregate care settings, QRTP or otherwise, is my experience is that residential facilities are trying to stick more to a 6-month date. Now, we all work with this population. It is not always possible. You know, sometimes it takes them a few months before they'll start working the program, but you know, but I feel like the vast majority of what we would probably be in a position to present to the court is gonna have to come from the residential, from the treating facility as to, you know, these are the goals we're still working on. And, you know, this is when we think we can get there.
Yeah.
But we, you know, we don't know because we haven't seen one yet.
And the last point on there about the efforts to find a fit and willing relative, guardian, adoptive parent, or foster home is key, because it's not a step-down residential facility. They're wanting us to find family-based placements for these children, and that is one of the things that these QRTPs are supposed to work with us on, is engaging, even if it's a foster parent, into the family counseling, into all the services. Yes. Right, right. So the next slide is where I have the, there we go, maybe. Okay, this is just the timeline that you may have seen this before. I know it's really tiny print, so you really can't tell what it says on here. But it just shows the general timeline for all the foster care hearings that you may already be familiar with. If you're not, talk to your CASA supervisor. It is on the Supreme Court's website. If you just search Virginia Foster Care Timeline, you'll be able to find this form. But the main reason I included that is because they created this nifty handout sheet, which anybody here already has in front of them. We also sent out the link to this. That's kind of like an excerpt or an addendum to the prior sheet. And this has the time frame on there. The forms that would be needed and the required findings. So it says there at the bottom, whether the needs of the child can be met through placement in a foster home, or if not, whether the placement in a qualified residential treatment program would provide the most effective and appropriate level of care for the child in the least restrictive environment and be consistent with the short-term and long-term goals established for the child in his foster care or permanency plan. And specifically, is that specific residential facility. Because if that specific residential facility is more restrictive than needed, then maybe that specific residential QRTP placement might be denied by the judge. And then you have to go through the whole service again. The next slide here is just the general foster care plan goals. And so I put on here, it pauses the timeline, which is almost kind of a fiction in some respect. But if you have a child that's under APLA, another planned permanent living arrangement, we're not going to be reviewing it in the same necessarily fashion as we are with a return home, relative placement, adoption, and trying to see where we're at on that timeline. So that it might be a 6-month review of seeing where we're at, but that can only be if a child is over the age of 16. And if you have a child that's in a QRTP, APLA may be the appropriate goal for that child if they are over the age of 16.
What did you say
Okay,
that
what is
stood for?
APLA stand?
Another planned permanent living arrangement. And so historically, before the whole QRTP process, we would use this APLA goal for children that were over 16. And we would almost do a lot of the same things here because it has those requirements that it be a least restrictive facility and things of that sort. I have permanent foster care marked out here because you can't have permanent foster care and QRTP at the same time, because for permanent foster care, you have to have a permanent foster care agreement that is signed by the placement saying that the child is going to reside there. And in order to move the child from that placement, you have to go back to court for approval. So that might mean that you have a child that's in permanent foster care, but now they need to be in a QRTP facility. You would actually probably file your petition for the approval of the QRTP before moving the child, unless it needs to be an emergency removal. So that's just one of those thoughts to think about. That's not a goal that would be option for the foster care plan. But you do file a foster care plan with this the same way as you would with any other foster care plan. Do you have any questions on that, or?
I think we've addressed the questions we had, yeah.
Okay. So what findings need to be made in a QRTP hearing? I've kind of already gone over that a little bit, but what I have actually here is this is a section of the actual court order that the judge is filling out. So this is what the judge is looking at when they are, actually, this is not the court order. This is the petition that DSS files. So this is what DSS is filing with the court by that 30-day time frame. So whether they have the written assessment of the report by the qualified individual, whether there's a foster care plan with that written assessment and what that goal of that is, and then is requesting for it to be docketed within the 60 days of the child's placement, not within filing, but the actual placement, and then who notice is given to. Child's parents, foster parents, guardian ad litem, the child if they're at least 12 years of age, any other persons the court may direct. And so one thing to think about is, have the parents' rights already been terminated? Because sometimes they have, sometimes they haven't. And that'll determine whether or not those parents will be involved, if at all. Yeah, you're good. Okay, so the next is, this is the excerpt of this specific court order. The beginning of the court order is the same as usual with the ICWA finding, Indian Child Welfare Act. So you always have that. You always have, you know, is the child in the custody of DSS or in a parental placement with DSS, those basic questions. But then specifically to the QRTP, these are the findings that the judge will make in the initial hearing and in the review. And this is in addition to the normal order that they would if it's a dispositional hearing or whatever. So when the child was placed in the facility, that the assessment was done by a qualified individual in conjunction with the FAP team. So that's also a part of it. That the needs of the above child cannot be met through placement in a foster home. And so a lot of times the judge may think, well, can the needs be met through even a therapeutic foster home? And then placement of the above named child in the qualified residential treatment program will provide the most effective, appropriate level of care for the child in the least restrictive environment and is consistent with the short-term and long-term goals established for the child in the foster care or permanency plan. And so there the judge can either approve it or deny it. If they deny it, you got to come back in 30 days.
And can I ask a question? So the child's family and permanency team, you said that's the same as FAP. That's not like a distinct entity that has to come together, or?
No, that's separate
Yeah.
from fact. So one of the forms that has to be submitted to the assessor, that has to be submitted to the court is an FPM. I'm showing it like anybody can see it, like an FPM. I know. I don't know what I think I'm doing. Family partnership meeting is a specific court. I'm not doing that.
Yes.
Court reporting form. So it's not just your generic, like it's not just any old thing you want to use to document. And so I was thinking a little bit about somebody early on asked a question about like CASA's role in
Mhm.
something, and like, I think, so the two that I'm most closely aware that we have, I think we have a third one that's in process, if I'm not mistaken, but I'm not the supervisor on that case, so I'm not as closely linked to that one. The two that I'm most familiar with have both been TPR, you know, kids who just have struggled with behaviors and haven't been able to make an adopted match and have had to go into residential. So theirs have looked different. But you have, this form is very specific. So on the front of this form, you are to list the family and permanency team members. And so that is whoever is the, you know, literally the family, whoever was invited to the family partnership meeting, as well as for children, I think they have made some changes. I think it's now 12 and older. Like they have, they say who's a part of their permanency team, who they want invited to the table. Yeah, 12, there you go. Yeah, I was gonna say, I think it fairly recently changed to 12. It used to be 14. And so this is where this is where I think of like the CASA, because obviously the CASA should be there 110%. So that's one thing for CASAs to keep in mind, is that there absolutely has to be an FPM in order to get through any of this process. It is a non-negotiable. There has to be an FPM. You've got to do it quick. You've got to meet all these timeframes. And so that's a key thing to be making sure, if for any reason, you know, your local agency is not keeping you posted, you know this has to happen.
So FPM stands for
Family Partnership Meeting.
Oh, okay.
Mhm, mhm.
And this has to be in the plan that
Yes.
is submitted with the petition for the hearing. So that means it has to happen prior to the 30, like if that plan has to be turned in at 30 days, you need to have this done by at least day 29.
And
At
it
the-
documents you know, what's the proposed placement, who's the family services specialist, what senior worker or supervisor was there, who's the GAL, who facilitated, what's the judge, who's the family and permanency team members, and then there's a section for other members, fictive kin. Like I said, this one was a little bit different because we had our adoptive placement there and some of those supports for this particular child. You go through the same thing. So you list the strengths, you list the needs, you list the goal, who's responsible. You know, can the child's needs be met in a family foster home? Is QRTP the most effective level of care? And that's really just as an outcome of the meeting. Did the meeting sort of, was everybody in agreement that the meeting decided this? You talk about placement preferences. Yeah, so it actually even goes so far as to ask you, was the FPM and any other meetings related to the placement or assessment held at a time and location that was convenient for the family? Please explain. Describe the efforts to identify and include the family and permanency team, including the opportunity for the youth 12 plus to select 2 members of the team. And if the goal is reunification, that the parents, prior custodian had opportunity to provide input on the team members. So you can imagine that, you know, you can't fudge this form, right? So if you say all these really great things happen and you get into your court review and your parents are there or your CASA's there, and so I never heard of this meeting, that's gonna be problematic.
Is
So-
so, and are you saying that form has to be attached with the petition that's filed? with the
Yes.
And I
court?
think, is that an addendum to the foster care plan technically? Maybe. I know that, so I have a lot of things you're talking about are here. It says the plan submitted for the QRT placement review must include, and a lot of things you were talking about are on this list. So I don't know, and I got this from the VDSS foster care manual. So I don't know if it's either this form is addendum or if it has to be somehow worked into the foster care plan. I'm not quite sure,
Okay, let me,
but I know that they're
Yeah.
submitted together.
Right, I mean-
It seems like they both exactly
Yeah.
have to be there together. They say almost the same thing.
They do.
Right.
So, but they have.
That's why I'm not quite sure.
I know that I read somewhere.
And the only reason I'm asking, I've seen one QRTP foster care plan so far. It wasn't with Lynchburg, but I didn't see that documentation, anything like that would be on that form. I didn't see that documented in the foster care plan, and also I didn't see that specific form, but also, again, it could be we're all just finding our way, but also I know too, because we've had this conversation with the clerk's office, I know there are some things that get filed with foster care plans, like the name of the child's school and doctor and different things, and like we
They
don't
don't get
get those with our foster care plans, so I didn't know if it might be something like that, or.
So I'm trying to just not take up time thumbing through papers, but,
Go back and see the court file.
but
But
I'm trying to just, I feel feel like
So
I
this is
saw
where-
that somewhere.
Shayna, this is the page that I had gotten all this stuff from.
Yeah, okay.
Foster care plan
That's what I think I
requirements.
was looking for.
But also, like, to me, this is one of the almost most exciting aspects. Like, I love the court review aspect of discussing the child's placement,
Mhm.
but also this is incredibly powerful because, again, like, at least two of the kids on my caseload in congregate care, residential treatment settings are kids that, again, like, basically, it feels like we've given up or, hit many walls along the way as far as potential less restrictive placements. So the fact that all of that has to be documented
Mhm.
and that the child gets to help choose, like,
And this is just the
That's
first page of
powerful.
requirements. There's another page, hold on. There.
Yeah. So in 6B.3.2.1 of the Child and Family Services Manual, Section E, foster care. Yeah, so the materials that are to be submitted to the court are the petition for the foster care placement hearing, the transmittal form, which for those of us, like, that's the form that tells the court who to summons, like who to have there. A foster care plan, the QRTP assessment, and that court reporting form, that FPM court reporting form QRTP version. So that absolutely has to be submitted to the court. It probably is a situation where it doesn't get copied. It's considered probably just those extra forms that don't get copied, but I bet it's in there. Like, it should be in there. It's required.
and also to connect back to, you had mentioned connecting to the question of how CASA could be. Again, especially depending on the age of your child, you should be explicitly talking to your child and asking them, who do they want present at their table? Who is significant in their lives? And also, not only should you be talking to the child about that, you as the CASA should have a sense of their family tree. Yeah, so that's definitely valuable information that you can be comparing with DSS, comparing notes, and or, just send an email with, the family tree that you've constructed, bullet points, what you know about the relatives, et cetera.
And what I can say is just, from years of doing this and kind of looking at this, like, obviously if we were to be in a situation where a child needed to be placed in a residential facility fairly shortly after coming into care, you can imagine that we might not be able to pull together the quality of family partnership meeting for this that we would be able to if we were in between disposition and review and we had more info, right? So it's going to kind of be, it's going to kind of be dependent on where we are, because the timeframes are so crunched. So what I will say is not, is that probably this is a situation where we need to be working really closely with our CASA to figure out how to help get as many folks to the table as possible to inform the decision. So again, Lynchburg as an agency, we haven't run into this yet, in terms of like that heightened time frame, but we will.
Okay, and that's specifically for the review, not for the initial QRTP.
For the
This is
initial, so for the initial, you do have to have her court reporting form that she was talking about.
Yeah.
And so
still
that
looking at
has a lot of
PM
these
period.
things in it. Now, this is the very next section, the 6B3.2.2, whatever, is the very next section that's talking about at the review. That stuff has to be incorporated into the next plan. So for the diligent efforts to identify those individuals and contact information, the documentation that it's held at an appropriate time and location. And where am I? I'll lose the mouse again. There we go. If the goal is unification, then the parents, prior custodians, that the assessment was done in conjunction with the family and permanency team, the placement preference of the family and permanency team, and whether that the placement preference differs with the child and the placement and the recommendation. So all those things are in the plan when it comes time for reviewing the QRTP. So my next section is the QRTP and the CASA report, which I know a lot of you are probably really curious about. There may be more things that we'll later think of that you all should add to your plan for this, but I just wrote down a couple that kind of stuck out to me, which are like, what are the specific diagnoses or needs of the child? Because that would determine the appropriateness of that placement. And does the CASA agree with DSS's recommendation for placement? Do they see that it's in the child's best interest or the least restrictive and highest quality care? All the things that we've been discussing. You can have your own independent assessment of whether or not we're fulfilling our end of the bargain on that. And then is there any family that can participate in the QRTP treatment or in the meeting that we were just referring to? Because with these discharge planning from the QRTP, we got to think about who can participate with them. For one of the ones that I have right now, I know it's a child who we've been trying to find a placement for a really long time. And one of the key things in us now trying to find a foster home for her is this foster home willing to participate in her discharge planning and do family counseling with her so that they know how to address her behaviors once she's in a family atmosphere? And so those are things that you can kind of think about, is there, whether it's, biological family or fictive kin or whatever that can participate in the process. And so those are things that I have on the next slide even.
And Katie,
Yeah.
can I, and Shayna, I'll kind of throw this out to you for your reaction. So I know sometimes, sometimes like in other FPMs, like things that make the final like action items, like it doesn't always necessarily reflect the full robustness of the discussion that occurred. Like, okay, here's one thing we considered, but we ruled that out because, and like one person thought this, but then there were kind of two conflicting. So I feel like sometimes in the CASA report, even for regular hearings, one thing that we can really bring to the table is to really kind of flesh out some of that discussion that occurred in the meetings. So I wonder if that also is sort of something that we can bring to the QRTP report, the CASA QRTP report. Again, really contextualizing and giving some additional detail to the discussion, and not just the final outcomes that were documented on the form. Does that feel reasonable?
Yeah, because again, I wasn't the supervisor that participated in this particular family partnership, but this family partnership was not a global meeting. It was literally for QRTP. It was only to discuss. Now, if we were to have one of these and it was early on in a case, I'm sure that we would be hard pressed to limit other conversation. And maybe you do them in conjunction with a regular family partnership meeting, but this is specifically designed to talk about like what are the behaviors that are going on right now? How did we get here? And what are can this child be served? And potentially to talk about where are we looking at placement. So yes, so if there's more going on, more to the story, like this is a limited, form, and this is to help inform the court's decision. But there's not a ton of room on here to write a whole bunch of stuff. Right. So yeah, in a report, you might be able to definitely capture some of those things.
Mm-hmm. And again, I just say that because just having been at meeting tables for various systems, including educational, sometimes the IEP meeting notes like say the IEP team decided, but it doesn't include any of the objections that I raised during the meeting, so that's kind of what I was thinking about. And I'm going to object to something.
It's just an example, right? That's just an example. It's not real life.
That's right.
It didn't happen. Yes, for example.
Yeah. And again, I can imagine if there's disagreement at the table, logic would say DSS is the one that's going to be writing the plan. They might tend to gloss or, downplay their disagreement.
Just like a regular family partnership meeting, like the participants have to sign. And I think, if someone disagreed, they would need to note that. I would be okay with, noting that. I don't, you've got sections, I'm just reading back over to see where you would note that, but you've got placement preferences of the family and team, including consideration of placement of the facility. So in other words, if the placement preference of the family was, I really want this child to go to grandma, like that's what we would need to write down there. But as a team, we would need to decide if that's safe. Sure. Is that safe? Is that in the child's best interest? Is grandma going to be able to meet the mental health, behavioral, emotional needs, whatever it is that we're experiencing? Yeah. Because actually, I'm looking at this form, placement preferences of the child and the youth, and the worker wrote in the home. Mm-hmm. She didn't want to go. She did not want to go. So, but she also knew that she had to. Like, she was sick. So, yeah.
And Amy Wilker had asked in the chat if the QRTP hearing is separate from the scheduled foster care review hearing, who gets it docketed? I would imagine DSS or DSS attorney.
Yeah.
Correct.
So if I were to go back to one of the slides from earlier about the petition that DSS is filing, that petition for the hearing is what causes it to be docketed. And a part of that petition, it specifically says on there that the case will be docketed within the 60 days of the child coming in to the QRTP placement.
Docketed.
Scheduled.
Okay. Put on the court docket.
Okay.
Mhm. And in Lynchburg, I mean, I like to think that we have a pretty good relationship with our clerk's office, because we run into the same type of scheduling stuff sometimes with fostering futures cases that have to have a judicial determination within a certain amount of time. So when we know we're in a crunch, like, we have been able to contact our clerk that we work most closely with on foster care stuff and say, this is when we have to have this set by. And that's worked for us, because it's critical. Because, yeah, you have to meet those deadlines or kids technically have to move. Yeah.
I was trying to, there we go. So this is the slide that specifically says they're under 1, docket the case for review to be held within 60 days of the date of the child's placement in the qualified residential treatment program. So this is just one of the pages that the DSS representative will have to file when they're asking for the QRTP hearing. This is the specific petition for foster care placement hearing, qualified residential treatment program. So if it's not in conjunction with another hearing, then they would need to file this. If it is in conjunction with another hearing, then I don't know if they need to file this in addition or if it's just a part of the initial petition. I'm not entirely certain of that.
And can I,
Well, actually, I think it does address that, because existing court hearing.
Yeah.
No, the petition and, yeah, you do. You actually file the petition for the type of hearing that's scheduled and the petition for the
So both.
foster care placement hearing.
Okay.
So, yeah,
So
you're alerting the court that you need both.
you need to.
Yeah.
Yep.
and just to double check myself.
Yeah.
Did we say that family partnership meeting and family and permanency team, that has to meet for that initial placement into QRTP?
Yes.
And then does an additional meeting have to occur like before every review, like QRTP review hearing, or just is that first one
No,
sufficient?
I don't think that it says that it does, but as we all know, as we move through the foster care timeline, like, those are technically at decision points where you should be holding them anyway. Or if you are talking about coming out of residential, then you should be having, that's
Change
a
of
critical
placement,
decision,
yeah.
a point of change of placement. So it should naturally,
All together.
yes.
It does say that the FPM court reporting form is supposed to be submitted. Well, that's for the initial stuff. So the form is included in.
Subsequent hearings, it's the policy, the guidance is a little
Sure.
short. It's
Yeah.
short. It's not a lot to it. It does not appear to specifically address that. I'm looking at the commissioner review because maybe that.
And so the slide that I put
Looks like it
back
doesn't
on the
specifically address
screen
that.
is the one for the court order for the initial child being placed into the QRTP. I did not include on here, but I wanted to go over the differences between the findings in this and then if it's a continued placement. So if you're reviewing that QRTP, the order does look a little bit different, and it has that when the child was placed there, that the ongoing assessment of the child's strengths and needs continue to support the determination that the child's needs cannot be met through a placement in foster home. That the previous approved placement of the above named child in the qualified QRTP provides the most effective and appropriate level of care in the least restrictive environment that's consistent with the short-term and long-term goals established for the child in the foster care or permanency plan. That the specific treatment or service needs of the child continue to be met in the qualified residential treatment program, and the length of the time that the child is expected to need such treatment or service has been identified, and that efforts have been made by the local Department of Social Services to prepare the child to return home or to be placed in an appropriate permanent placement. And then it also includes the, in the petition for that, it includes the case to be docketed, and then it gives the different sections for the worker to check off. Is it a foster care review, or is it a permanency planning hearing? What is the specific hearing that they're going for and reviewing it at subsequently?
And if the permanency plan identified for the child is independent living, then that also is an acceptable, but you just need to show how you're preparing the child to exit that setting.
Right.
Is that right?
And I just will say that independent living is one of those things that's a little bit of a quagmire, you know. It's hard to figure out because of the fact that we can't have independent living as a goal until the child is 18. So that's actually fostering futures. Now, we do put children in independent living placements when they have other goals, namely relative placement, or maybe even return home, depending upon the circumstances and whether or not we've had a TPR of some sort. But we can't actually have independent living as their goal until they're in fostering futures. Now, if you have somebody who I guess maybe is in residential until after 18, which actually had one, that a male that was in a residential placement until he turned 18, and at that point decided, or I guess it might have been a week before, was able to go into a independent living situation. So for him, that might be the sort of situation, but a lot of times that's not exactly.
I have a question.
Yeah.
Since we have, this one's carrying the QRTP specific findings, when will the CASA know what those findings of what the reports from the residential treatment program? How's the CASA gonna get that information?
So I would hope that a CASA is as involved as possible with that process.
So that the CASA would get it directly from the treatment program?
Yeah, you all have access to the
Just
medical
like-
records, so
Okay,
yeah.
Just making sure.
And so if there is a treatment team meeting at that residential facility, like I would hope that you all can be included
Okay.
in that as well. And if that's happening on a weekly or monthly basis or whatnot, I know the one QRTP case I have right now, the CASA is highly involved in it, and she honestly is what has partially been our saving grace in it, because she's ensured that our workers are doing what they need to do, and sometimes it's a hard thing. And, she has been involved in every step of the way, and I'm getting it. I somehow ended up getting on the string of emails of this child's updates each week. And knowing that she's on it and that she's replying to it and the GAL's on it and replying to it, that open communication with all the parties and players involved is really what helps the best interest of the child be accomplished in the best way possible. So yeah, if you know when those treatment team meetings are happening, then attend them if you can. If you can't, then maybe follow up with the doctor, the day or two after and say, hey, can I get a copy of that report? And then of course we file our foster care plans usually 30 days before the hearing. So you should be looking out for that foster care plan. That way you all can see what we've actually filed.
Yeah, and as long as you're having frequent contact with the treatment center, then again, usually they're going to be inviting you to those meetings, and if not, then you need to explicitly ask about them when the next one's scheduled, to make sure they know that you want to be part. And then also, you should get on the email list, because they'll send out a monthly treatment plan and summary anyway.
I remember getting them as a teacher, like, very much like, I had to sometimes like, hey, where is it?
Right,
Make sure, like.
When is
So the next thing that I was going to talk about a little bit is who else is involved other than just the CASA. The parents should be involved if their rights are not terminated, as much as possible. That should be with the family therapy, that should be with the FPM meetings, that should be with every single step of the way. They will have an attorney is appointed for the specific QRTP hearing, the same as any other foster care review hearing. And so they also have that resource if they have any questions. The CASA should be involved with the parents if they're still in the picture, that sort of thing. I included family and fictive kin on here, and the question is asked, what is fictive kin? Fictive kin can be a soccer coach. It can be a church member who the kid has had a former relationship with. It can be anybody who is invested in the child's life and wants to be a part of their community that is appropriate and willing. And a lot of times we look at even these people as potential placements for the child. A lot of times with these children, we may not be able to find a stranger foster home for them because their level of need and care is so high. And I actually had the judge ask the CASA the other day, would you think about taking this child in? Because to some extent, a child or a CASA can, after working with a case a really long time, almost become fictive kin, even though you all are actually in a professional role and do need to have professional boundaries and that sort of thing. So it was definitely inappropriate for the judge to ask that, but I understand he's just fed up with us kid not having a placement, and seeing the bond that the CASA has with the child was where he came from.
And that is a good question, because I think I know which case you're referring to.
Yeah.
And I think this could be sort of a theme in many of our cases. So what if, let's say DSS files the foster care plan, and what if the residential placement is saying, no, this child doesn't need to be here any longer, but the barrier is that we can't locate a placement for them. And I guess will tell us, but maybe theoretically, the court could say, no, I don't approve this placement because it's not medically necessary. So what happens then? I guess just we can't use 4E funding for the.
I think it said you have 30 days to remove that child from that placement. So you have funding for an additional 30 days, basically. And it may be that facility is not appropriate, but maybe there is another placement that is appropriate if you can't find an actual placement for that child, or maybe the child has to go into shelter care or something. If we really don't have a family-based placement, maybe it'll have to be something that we have to just suck it up and use local funding on. I mean, that's what hopefully encourages us to find a family-based placement as soon as possible, but we do have cases where we can't find families, and we do engage with different services as an extra special families or parents or whatever. I'm not sure what that exact organization is. There's different organizations out there that we specifically work with trying to find families for this especially hard cases with a lot of these diagnoses that need specific circumstances. But one of the requirements for these QRTP is that there is that discharge plan for a family. And so like the child that I know, I'm working on her case right now, she is in a placement where they will not discharge her until there is a family identified and until there is family counseling put in place to appropriately discharge her. So they're not going to recommend her to be discharged until those steps occur. And that's part of built into the QRTP process, is they need to have that family identified to get the child into a family atmosphere.
And did I see in one of the slides that also one of the prongs that makes QRTP is that they are working with the family? And so let's say if the child, is allowed to call home to mom, whether rights have been terminated or if they haven't, does that, like, allowing family calls, like, does that fulfill the requirement, or like there needs to be more, whether that's like the parent needs to be integrated into some therapy sessions with the child, or like do additional members of the family also have to be identified and accessed?
So the language that's on these two slides says facilitate outreach to the family. I do believe that some of the guidance may have a little bit more specific language on the parents and family role in that. I know that's a lot of like the family partnership meetings of incorporating the family into the planning.
I would venture a guess that is really addressed elsewhere in guidance as an overall engagement issue. So, if we've got an active foster care case and we have, especially a young child, and we're still in the midst of the foster care timeline, and we've got a child in residential and we're working on reunification, then we should absolutely, like, it should be much bigger than just this is who your your daily phone call goes to. I can say that we've got a young man in a residential, I say young man because he's young, he's really young, a little boy, in a residential facility, and we've done a ton to facilitate working with the service providers, getting them up there every weekend, and it's 2+ hours, I think. I mean, it's not close, and that's what we should be doing. I mean, that's what we should be doing. That's a, you know, it's a CSA service. That's taking the parent to the child. So it doesn't, he's not 40 anyway. But, yeah, but that's what it should look like. And it doesn't have to be that. I mean, he's young, and so, and we have parents. I mean, we have parents that will go do that. Not every parent is really gonna make that commitment either. That can sometimes be tough. But it should look like virtual contact or telehealth. It should look like family. It should look like family therapy. So.
And I think it also goes into the providing family-based aftercare for at least 6 months after. If we're already working with that family, or the QRTP is, they're gonna be much more inept to provide that afterwards. Otherwise,
Yeah, I'm super interested to hear about that piece some more. But also, I just wanted to mention, Lori had asked a question in the chat. Is there any difference in this process if the child is moved to another facility or even to a facility out of state?
so yes, there is a piece of it when they're out of state. I did not actually focus on that. I saw that somewhere. And I'll tell you that most of where I got this information from, and I can go, we've pretty much gone through everything at this point. I was on the question slide. So that is a question that the answer is most likely found at the web's address here.
Yeah. So for out of state, you have to follow ICPC, the Interstate Compact for Placement of Children. You have to follow ICPC guidelines for placing and QRTP. If it is a QRT, if it meets the requirements and is designated and can prove it's a QRTP, then you still have to follow. Now, I don't fully know the question. I'm not sure 100% understand the question about moving, but what I will say is, because this is what's really interesting, I can give you a for example. If you look at I'm not going to hold it up, I can't see it. If you look at the list of approved QRTP providers, you'll see that Intercept is on there. Okay, Intercept, if you're familiar at all, they have a host of group home locations. Now, they do a lot of different stuff. Intercept has TFC, but they have group home placements. And they're all over the state. If you move from, if you have a child placed in one of those, because it's QRTP, if they move from Richmond to Roanoke, you start over again. You do it again. You know, if they have something happen in Roanoke, they move back to Richmond, you do it again. So if you move from QRTP to QRTP, it does not go with you. You start over.
Because these treatment facilities, a different kind of care technically, you want to assess that that's the correct.
Yes, but
level
that's
and meeting all the needs, so
specific.
that's specific, not just-
Cure, yeah, it's not, does this
That's
child
fine.
needs a residential placement? It
Right.
is this specific qualified residential treatment program? What is the best for this child? Is it the highest quality and least restrictive for this child and their specific needs?
Yeah.
And so it is a very much case-by-case basis for that specific child and that specific facility, given whatever the current circumstances. And maybe one of the reasons why it might not be the best because it's too far away for the family to participate in family counseling. Maybe there's one that might be better in one area, but not in another. And so there's so many different factors that go into assessing it. I know a lot of the facilities that we use, Oak Hill, Child Help, Grafton, Hallmark, Intercept, Hope Tree, North Springs, all of these already have their QRTP designations.
Now, where did you get that list? That could be a handy.
It's on the Family First website.
Okay.
It
Yes.
is on the Family First
Do
website.
you want me to show the website? I guess I can.
Yeah, put
Yeah.
that link there.
And if you go.
I'll exit from the PowerPoint and then let me share my screen again.
I know how you feel.
Minimize
Because I think I saw it when you had all those little windows up. I think I saw the website because I've been on it. I saw the little
Yeah,
fellow,
there we
yeah.
go.
So if you look under, if you go under foster care, there at the, and QRTP providers, and that is supposed to be,
Yeah.
they're supposed to keep that really up to date. And you'll see right under that was SUD facilities, which I think is substance use disorders, which I could not, that there is, we got word, I believe this week, that there is finally one I have to go back and look, maybe maybe it's one in Virginia that's been
Amazing.
qualified that has been made eligible for qualified residential treatment, and that is supposed to be where an entire family.
Yes,
And go
they're
and live. The
family-based
parent would go, I
substance
know.
programs.
It
Yeah.
sounds right, great. It's just not something we've ever.
That's great.
And since it's,
Well, there you go. I mean,
and since it's
that's-
family-based, it doesn't need to be the QRTP because the child's not a
Right.
family.
And so what that is, so that's been determined to be evidence-based. And so it's a program that meets the requirements and you can use that and use your 40 fund.
Yep.
That's what that is.
Now, that's just as of July 28th of this year.
Yeah, I was gonna say, we
Very
just got an
new.
email that there was one.
Yeah, pretty much.
And the children.
It says women's residential treatment center, so it may just be specifically like a women and children's
Yeah.
type thing.
Which you're probably gonna see more of than co-ed, I bet. You know, just saying, but yes, so that's just, I knew with Family First that was something that, you know, was an approved, setting, but we didn't have one, so I don't, you know, didn't know what that might look like. I don't know anything about that program. As you can see, I'm not saying the program is new, but obviously its designation is new. But yeah, we just got word not that long ago about that.
That to the QRTP. So,
Go under foster care. And then
Oh.
QRTP.
Yep. No.
Sorry, the providers is what we were originally looking at.
And this is the QR code will take you to this page of the frequently asked questions and.
Yep, there it is. And you'll notice that a lot of the wording in here is the exact same as the PowerPoint, because I took it straight from them,
Yeah.
because they've got it done
Somebody's
accurately.
reinventing the wheel.
Yeah.
So this is a very extensive and lengthy frequently asked questions page,
Yeah.
so hopefully it'll be helpful. Yeah. Yeah, but I am very interested to hear more about that sort of aftercare after they're discharged from the facility. So does that mean that the facility only has to coordinate that care to be available to the child upon discharge wherever they're getting sent? Or does the facility themselves have to provide that?
Because that's a locational issue, because the facility's like 2.5 hours away from where the family lived, it doesn't seem reasonable.
Yeah.
But to make sure that that's in place upon
Oh,
discharge.
here we go.
You know, yeah, that could be in the frequently asked.
That's what I was
questions.
actually
Yeah,
scroll- I
was
printed it
looking
out.
behind the
That's what I was
neck
looking
of the
through,
so-
yeah.
But you know, I would think that part of that may just be making sure family is connected to aftercare services, and that the facility may have to follow up, like make sure that those things are still in place so that it's happening. And so I would think.
I think it
You know,
might be
I
a
would-
combination, because one of the frequently asked questions, we got a whole discharge planning section there. It discusses that they can actually charge part of the discharge planning and services as part of the initial residential placement, so that 4E can be helped with that funding. I think if it's not a part of the original residential placement, it has to be done either through local or Medicaid.
Which, you know, if you have a child in foster care, then theoretically, like, if we stepped down from a residential facility, we've made a placement, we should be having those support services in place. We should have those aftercare services in place. You know, whatever that looks like. And I would think that would be like a coordination thing, would be a part of what they would need to do. Well, no, mine doesn't apply to this child. So, yeah.
Very interesting. And I think someone had asked about prevention services, but Family First, it is a federal piece of legislation. And again, it does, like, the whole goal of it is to increase family-based placements and decrease out-of-home placements. So that includes prevention and sort of, go ahead.
Sorry.
Nope.
So,
Go ahead.
you know, one of the things so obviously, like, 4E money is 4E money. So what part of what they wanted to do with that 4E federal money is put it on the front end. So to do that, you got to figure out how to take it away from the back end a little bit. Like, that's just what they did. They just rearranged some of the monies, and this is how they're doing it. And that's okay, because what they're trying to do is beef up prevention, beef up, you know, services to families to prevent them coming into care and to prevent, or even to prevent the necessity for an out-of-home placement, you know, into residential that's separate from being in foster care, like just, so they did take, you know, what they're gonna probably save in some 4E money, either by shortening shortening eligible placements or by, not using QRTPs, and so you don't get to access that money. And they put it in the front end. And so you can see on that website that there are some specific evidence-based prevention services that you can now use for it, which is never, 4E has never I've been here 22 years, there's never been a service that's 4E eligible, ever.
And you're talking about, this is before a child comes into foster care.
Correct. This is completely separate from
Prevent
foster care.
coming
This
into
is
foster care.
this is
Yep.
straight up prevention service, prevention of abuse and neglect, prevention of out-of-home placement, and it's your evidence-based therapies. Now, the thing that I have, I don't do prevention, so I'm not as active at all on that side of things, but the thing I find interesting is that what I've heard is that all of those are Medicaid services. So I'm not sure that, I can tell you that our agency, to my knowledge, has not utilized 4E funding for those services, for those prevention services, because they're all Medicaid funded. But, so it's just, that's just an interesting dynamic. I don't have anything to say on that. It's just interesting. But
So-
yeah,
So if it's all Medicaid funded, if the child not uncovered under Medicaid, then it can't get services.
so in the event that a child was not covered by Medicaid, on the prevention side, 4E federal funding can now be used to pay for that. And so that is a huge benefit. It's just that we don't frequently see or work with a population that's not covered by Medicaid. That's just the reality. But it would certainly be there if.
This is a little topic. Is 4E like available now at schools, like to help with counseling at schools?
It's, well,
Because I've had children be like, we've had like behavioral health programs in schools, like day treatments and but only if you were medicating people. And so now, like, okay, this little child needs this too, and he's not in your the school facility, but we couldn't let this child go into the small group for kids because there was no payment for it.
The school stuff has changed a lot even recently. Like now they're not even saying day treatment. There's different terms for a lot of different things. So I honestly don't know any of the
Okay.
school stuff.
and also, at least if a child is not in foster care, I know there's also like certain criteria that they have to meet to become 4E eligible. Like if they're not in foster care, you might know more about that than me. But also this little box listing services here, right now, these are the only
Mhm.
3 services that are in Virginia as an entire state that is eligible for 4E funding if a child is not in foster care. So part of the bill, like it creates criteria for meeting the definition of evidence-based services. And Virginia is in the process of sort of increasing their library of services that would meet the criteria for 4E funding for prevention. But right now, this is what we got. And I will say, I know we have at least the parent-child interaction therapy. We have a local provider for that. I can't remember about functional family therapy.
We do. We do
Okay.
have some local
Is
providers
that
for
what you
that.
just sent us something about?
Yes,
That's strategic?
yes, I think so. Yeah,
Mhm.
that's true. And strategic, I can't remember their full name, strategic therapy.
There's
Um,
therapy associates.
Okay,
Mhm.
strategic therapy associates. They're having like a training, it's an all-day training coming up sometime this fall to kind of teach about parent-child interaction therapy,
Mhm.
what it is, et cetera.
Yeah.
So if
No,
you're
we do have some local providers of FFT and MST.
Okay,
Horizon, but I think also,
that's right. Okay.
I get it wrong every time. Life Push,
Yes.
Life Push. I always want to say Family Insight,
Mhm.
and they might do it too, but Life Push. I
I
know.
know it's a great organization, and my son got that, and they were so beneficial.
Yeah, I mean, they're, I like them. They do some good work. You said something, so what I think, what is that called? No, I'm not gonna be able to think of it. Trying to think of what, it's a reasonable candidate. I believe it's probably based on reasonable candidacy, which I don't know a ton about because it's on this like CPS prevention side, but there has to be some criteria, I think, for someone who would be a reasonable candidate of foster care, which has to probably speak to at risk and that sort of thing. And I'm assuming that it probably follows that. in terms of eligibility for that 4E. I don't really know enough about how that works. So I guess what I would say is in terms of schools, if any of those therapeutic interventions can occur in a school setting and a child has an open prevention case and 4E, like, but as a general rule, like I don't think just, at the very least, they'd have to have an open prevention case, I think, with a locality.
And a lot of the prevention-based services are not mandatory. It is the family wanting to participate in these prevention services?
Mm-hmm.
And so if the family is refusing and they're saying, no, we don't want to engage with DSS at all, then we're not going to be able to help. And that's where we end up having to come in at the tail end of things.
Yeah, so that first bullet, a child who is a candidate for foster care, but who can remain safely at home, which I guess really just means they're on the cusp.
I mean, a lot of our protective order cases is a
Yeah,
child
yeah.
that is eligible to come into foster care. Like we have an instance of abuse or neglect that occurred, but we believe this protective order will prevent a future instance of abuse or neglect from occurring as long as certain, things are in place.
Yeah, and it looks like basically they have to be a DSS involved child or family because in order to access the funding, one of the criteria is that there has to be a DSS written prevention plan.
Because I think 4E is a DSS program. Like I think it's a DSS program, so I don't know that you can access anything related to 4E outside of DSS. So that would make sense.
Okay, any questions that anybody has at the moment? Can you maybe talk us through a little bit, like what are the findings that the judge would make at a QRTP hearing, and even do you think there would be a sample order like on the Supreme Court of Virginia?
There is, and so on the slideshow, I did put one of the slides that we had gone over had the court order on it. So I think it's the second one, maybe the next one down, 22. Yes, so this is the specific QRTP findings right there. So when the child was placed into the residential facility, that the assessment was done by the qualified individual, on which, remember, that has to be a mental health provider, something of the sort, that the needs of the child cannot be met through a foster home, and that the placement of the child will provide the most effective and appropriate level of care in the least restrictive environment and is consistent with the short-term and long-term goals established for the child in the foster care or permanency plan. So those are the very specific QRTP findings that are required to be made. And of course, each one of those findings has a lot that goes into it, as we talked about the different process with the family partnership meeting and that sort of thing. But all these things should be asserted in the petition, which is the slide before that. So DSS, they're submitting this petition saying that all these things have occurred. And so then the court order is basically, yes, these things have occurred. So that's exactly what the judge would be signing.
Okay. And if for some reason, let's say maybe a step had been skipped, like maybe they didn't hold the meeting or the written assessment wasn't included with the plan or something, then I guess, I don't know, maybe the court would just order
Deny it.
those things have to be done. Okay.
They could deny the placement, and we have 30 days to, I guess, either remedy and refile the petition again, or to move the child from that placement.
Okay, so kind of like if a regular foster care plan gets disapproved,
Yeah.
then you have to have another, come back with an
Yep, 30
updated
days,
plan
yep.
and- Okay.
So one of the things is there's a very specific checklist process, and so there's this more so than a lot of stuff in foster care. There's a lot of stuff that you can't do one before the other before the next, and so we can't go to court. I mean, I guess a road worker could just try to file some stuff, but you can't go to court until you have the QRTP assessment back that says yay or nay. Because if they say no, you don't go to court anyway, really. I mean, so you kind of have to have all those things in line. That's why the timeframes are so stringent, like they're so important, because you've got to have all those things, then file it with the court. So
I think one of the rare circumstances I can maybe think of is, say we have disposition, and 3 days before disposition, something happens with a child and suddenly they need to be in a QRTP, but we've already filed a plan, we already have a date set for court, and we're not gonna have enough time to get there with the QRTP stuff. We could technically go to disposition, approve a plan as normal with a return home goal, relative placement, or whatever goal might be appropriate, and then still submit the QRTP process later, which would be before, the 4 months, because we would still have to do it within the 60 days of the child being placed there. So you might have a scenario where you have to go to court twice within a weird period of time, just based upon the weird way that time frames can fall. I think that might be the only situation where like maybe a worker might try to like file the QRTP stuff the day before, but we may not have all the evaluations and stuff. And so it really would be inappropriate. We should really wait and do it at a separate hearing at that point.
So you would just file it as soon as, like, get all this done right now because we can have another hearing. Because of that foster care plans.
You would still want to have a hearing. So
Yeah.
if you don't have enough time to get everything done you need to get done before your filing of the foster care plan, you're just gonna have to file a new foster care plan and do it within the 60 days.
And DJ Jenkins, to answer your question, you might have asked that before we showed you on the website the list of QRTP providers, and I'll go ahead and put that link again to that website in the chat. Yep. And Shayna, I'm curious, have you guys, do you feel like your agency has seen a financial impact yet from sort of the increased QRTP regulations?
Oh, before she answers it, I will add, there was a grandfathering in of those that were already in a residential placement prior to the enactment of this. So for those children, the answer would be not yet.
I would say no. Now, I am fairly active with CPMT and CSA and do know a little bit about budgeting and stuff like that. So, but I would say no, that there probably has not been. One of the things, and I know we're not gonna get you deep over into this, but like one of the things I know that my local CASA folks here know is that we've really, really upped our kinship program and our fictive kin program. That's 100% what this is designed to, I don't want to say force agencies to do, but that's what it's designed to try to kind of get you to get down this track, right? All this is entirely too much trouble. So just find your family placement and make your family placement. You don't have to do any of this. And so we already have been trying to, increase our program in that way. And, family tends to, be able to better meet kids' needs, or kids just do better. So I think we've always had we keep our congregate care numbers pretty low. But, what I will say is that even though this is a pretty good list of QRTPs, like it's not all inclusive. So there's still lots of, some congregate care placements outside of this that we utilize. Again, we have a local, treatment facility here that we like to use if we can, because we like the quality historically of their program, and it helps with family, it helps reunification, it helps with keeping family involved because they're right here in Lynchburg. They're not on this list. So if we have that need and we think that local facility can meet it, we're going to try to get in with them. We're not going to look for that QRTP. That'd be more of a CSA thing if they've seen more of a hit from a reduction in being able to utilize 4E funding, but just kind of trying to brain on the placements that we're using. I've also seen, for whatever reason, an uptick in kids being found 4E ineligible recently, which is just an internal Lynchburg DSS thing that I've noted from having been here a long time. Is I see a lot more ineligible, and I would love to delve over in that a little bit more because I don't know exactly what it is, but and that makes a big difference because if the child's ineligible anyway, there's no, there's no federal there to recoup anyway. So I haven't seen it, and I don't hear pressure from the CSA office, which tells me that it hasn't been a huge hit yet.
And can I repeat back something you had said earlier? I just want to make sure that I'm correct on this and tracking with you. So you said even if a facility is not on this QRTP list of providers in Virginia, if they're in a congregate care setting and they're in foster care, we still have to basically go through the QRTP court review process, or only if they're on this list?
I don't think I said that. I think what I was talking about was even if it's just a CSA child and it's a QRTP, but no, like that, so that wouldn't be accurate. So one of the things that I keep, well, at my office, and I know where it is, I was gonna see, keep right in front of me all the time, and of course I cannot find it, the state very early on gave us a very helpful document, and it's a funding decision tree. And, gosh, it's sat here the whole entire time, and it doesn't matter, but you basically just start at the top, and it says, like, you know, is the child in a psychiatric residential treatment facility? If yes, then, you know, you don't go any further. Medicaid covers the entire cost. No, you know, okay, is it a QRTP, or was the placement prior to July 1st? And so you go straight down the list, and it tells you whether or not you have to follow the process. And if you get to the point where it says, is it QRTP, and the answer is no, then it says Family First doesn't apply.
Okay.
So you just don't do it. Now, Catherine and I talked a little bit earlier, and I know this won't mean anything to you all, but on the DSS side, we have frequent congregate care reviews from the state. So the state still has a very vested interest in pushing the agency to not let children linger in residential. But, you know, this process only solves it for 4E QRTP. The state's got this other congregate care review process to put pressure on agencies to be having conversations about when this kid's coming out and what's the step down plan and when was your FPM and what kind of conversations are you having with your supervisor and that sort of thing. So there's a whole other process for congregate care that applies to anybody that's in that setting.
And does that, again, just because some of the kids that might fall under, basically, some of the kids on our caseloads that are lingering in these congregate care settings, some of them might be QRTP kids, some of them might fall into that other category.
Mm-hmm.
So can you speak more about that? Like, does the state, like every 6 months, they sort of, it's a scheduled recurring, every 6 months meeting, they sit down with each DSS agency and kind of review the list? Or is it like it triggers something if the child stays over a certain period of time in a congregate care setting?
The state reviews our online system, what we call OASIS, or not just we, the whole state. The OASIS system, they look at the placement screens for all kids, and then so like for instance, our Piedmont person is Dawn. Dawn will look at the list of placements for Lynchburg, and then she'll email us and say, this month you have these due for I'm going to do a congregate care review, and then there's significant follow-up. So there's like action steps, and then when she somehow gets, I mean, you have to kind of see the way the email is set up. You can tell that it's a triggering device for her. It's something that's sent to her that says, this is when you had this conversation with the agency, these are the action steps you told them to take, you need to follow back up. And she'll send an email to the worker and to the supervisor and say, these are the things that we discussed. Let's, give me an update. So it's reviewed frequently, and then as new ones come up, she's just constantly reviewing that list of who our placements are, and either reviewing new cases as they come up or going back over old cases. So I think it's actually more frequently than 6 months.
Okay.
Not everything is a specific phone review. The phone reviews take about an hour. The follow-up emails, a lot of the follow-up thus far has been done by email.
And remember that like our court reviews also have a place on there for the judge to ask the child about their desired permanency outcome and that sort of thing. And if their desired permanency outcome isn't residential, which what child's is, I mean, occasionally we see a child that says they prefer to be at the group home than in a residential facility or something, or in a foster home. But most of the time they're not going to say that. And so every court review is an opportunity for that placement to be reviewed and the appropriateness of it to be reviewed, whether or not it's a QRTP. And the judge has to make specific findings that that placement is still in the best interest of the child, if it is an APLA placement or if it is any kind of non-home placement. They do make those determinations. Earlier was asked what is 4E funding, and I actually have a part of the code in front of me, and the actual title for 4E, it's subchapter 4, grants to states for aids and services to needy families with children and for child welfare services. Part E is the federal payments for foster care, prevention, and permanency. So that is the title to the section of 4E.
Got it. So, okay, Lori had a question, and I guess it kind of tied into a question that I was wondering about as well. So again, I'm kind of thinking of a specific case on my caseload. If there's a child in a facility that would be a lower level of care than a QRTP, and everybody's, initially the child was slated to go into a residential setting, kind of we're all shocked at how well they're maintaining in a step down placement, a group home setting. I mean, what would be, because what I'm concerned about happening is if the child gets moved to a QRTP setting, maybe she doesn't need to be there, but I assume that the assessment within the first 30 days of the residential setting would reveal that. But I'm so concerned about, like, well, then the placement's already disrupted and we have a lot of.
I would think so. I think that another thing that we've seen, and I know you've seen it in the number of years that you've worked with this, is there's often a honeymoon period when a child is in a placement.
Yes.
And so if the child has only been in that step down facility for a weekend or a week, we may not actually see their actual behaviors yet. And so if they're just temporarily there before we can get them in the facility we think that they should be in, it might be because of that. And that assessment will determine, maybe they are better to be in a smaller, less restrictive environment. But oftentimes when they're in that lower needs facility, it's not one that's actually going to be able to meet their long-term goals. Most of those the short-term facilities aren't made for long-term goals. And so that's the question is, can they provide what's needed to transition them back into the community, back into their family? Can they provide the aftercare and things of that sort?
Yeah, and one of the things I'll say is that, again, and I think it was in the beginning of some of the stuff that, I think it was in the beginning of your PowerPoint, or maybe just something that you said, about older kids lingering in congregate care, that sort of thing. Again, not to like harp on this issue, but like I've been here a long time, and you are not necessarily, like, the state is never gonna be able to put a program like this into place and fix the fact that local agencies struggle to find placements for very difficult to manage kids and teenagers and CHIN's youth and delinquents. This is not going to change that. And so this local agency is, what they're trying to force us to do is, there's some agencies who don't work on it at all. That's the reality. There are absolutely, of course, some agencies across the state that just use congregate care, I'm sure, because it's simpler. And, that's not our reality, but having worked for years very closely, especially with the older population, like I've always kind of been the supervisor that works with the IO youth and the independent and the teenagers. CHIN's youth, and they're a difficult to place population. They're difficult to place back with their family. They burn bridges. They do those things. They have to go live somewhere. They have to live somewhere while they're in foster care, while we try, while we give them an opportunity to change their behavior and make some improvements. And so, QRTP doesn't fix that. The agency's still got to find safe placement. We've still got to find somewhere where they can lay their head down. So we have to make those placement decisions and then figure out the rest on the back end. Like and it may not be ideal. That may mean we get stuck in a situation where we place a kid for 30 or 60 days. We may be in a position where a kid is there for 60 days before we find out they can't stay. And maybe our CSA says, hey, we'll flip this for another 4 months because it's okay. Like, those are things, those are bridges that for me, we're just going to cross when we get there, because if I've got workers over at the agency and we're faced with a couple nights, spending the night at the agency with a kid, and we're going to put that child wherever they can go, where they can safely sleep and have their own room in their own space in their own bed. That's what we're going to do. And luckily that hasn't been our experience. I mean, not never, we have had it happen on a much lower scale, but that's what we'll do. We're going to make a placement and then we're going to figure the rest out.
And that FPM that has to happen tied to the QRTP support hearing or happening in advance of the QR, does that have to happen in advance of the placement at the QRTP setting or just?
Within,
Before the
it's
court
within 30
review.
days, because that has to be incorporated into the foster care plan that's submitted with that petition that has to be filed by day 30. So really, you're looking at like a 2 to 3 week time frame to get everything done so that you have it ready for that filing by that 30-day deadline. Because, yeah, these workers have other stuff going on too. I see that Lori asked a question there of the push for children to be admitted to residential facilities as opposed to the detention center for the safety of the children and those around them. And I would say my experience is it depends on the judge. I feel like there are several judges that will sometimes place children into foster care instead of detention facilities, when that may or may not be the most appropriate placement, but they don't know what else to do. And so then oftentimes as an agency, we are stuck with children in foster care that don't need to be in foster care from our perspective. They may have parents that are even appropriate, but there isn't another option. And so sometimes they may end up going to a residential facility, but more often than not, the residential facility that they end up going to is not a QRTP because it's not mental health needs, it's behavioral needs. And while behavioral needs can be addressed through QRTPs, most of the QRTPs are not designed to address behavioral needs. They're more for mental health. And of course, like Elk Hill does behavioral needs. Some others do as well too. Most of the time you have to qualify to get into those behavioral need programs. And a lot of those that are ripe for detention may or may not even qualify for a non-locked facility of that sort. And so looking at flight risk and all the other concerns that go with it, we do have a number of children that end up coming into foster care that may be better suited in detention, but they're getting grace for the moment.
Yeah, anybody in the chat or anybody in the room have any last questions? I am going to work on pulling up the review is only the evaluation. That'll also have a QR code that you guys can go in there and give us feedback about how tonight was for you. But again, please be putting your last questions in the chat as I pull that up. Yeah, thank you. Truly, this has been very informative. I know I've learned a ton. I hope you guys felt the same.
And I know the last slide of the slide said, the things to look at is one, the Family First website, which we've already gone through pretty in depth. You can also talk to the caseworker on your case. Now, they may not know a lot about it, but they can always ask questions of their supervisors. You can always ask your CASA supervisor. They may have some information. And of course, you can always reach out to your DSS attorney, specifically me, if you have any questions. The other attorneys in the office are learning just as well. This is all new for everybody. And so if we don't know the answer, we'll help you find it.